Good evening, sir. Good evening, classmates. Group 8 will report on Chapter 17, Torts, and Chapter 18, Crimes on Conflict of Laws. Let us first define what is tort. Tort is the legal wrong committed upon person or property independent of contract. In Spanish law, the concept of quasi-delict or culpa aquiliana includes all acts or omissions committed through fault or negligence, causing damage to another independent of contract. In American law, however, tort has a broader meaning, for it covers legal wrongs not only committed through negligence, but also those committed with malice or willful intent. But of course, independent of contract. Otherwise, it will be breach of contract and covered by another field of law, which is the contract law. What is the concept of tort in the Philippines? Our concept of tort under the new civil code is a blending of the Spanish culpa aquiliana and the American tort, which may be committed not only through fault or negligence, but also with malice and willful intent. Thus, Article 20 of the new Civil Code provides that every person who, contrary to law, willfully or negligently causes damage to another shall indemnify the latter for the same. On the other hand, to retain the Spanish concept of culpa aquiliana or quasi-delict, Article 2176 of the same code provides that whoever by act or omission causes damage to another, there being fault or negligence, is obliged to pay for the damage done. Such fault or negligence, if there is no pre-existing contractual relation between the parties, is called a quasi-delict and is governed by the provisions of this chapter. In conflict of laws, what law governs liability for torts and what are the reasons for the rule? Liability for torts in general is governed by the lex loci delicti commissii, or the law of the place where the delict or wrong was committed. The reasons for the rule are: the state where the social disturbance occurred has primary duty to redress the wrong and determine the effects of the injury, and number 2, to compensate the victim for the damage or injury suffered. In applying, however, the rule of lex loci delicti commissii, how is locus delicti determined, especially if the wrongful conduct is committed in one state and the injuries are sustained in another, or the conduct is a continuing act that spans several states? There are at least 3 theories in determining where the locus delicti is. The first theory is the civil law theory. The locus delicti is where the act began. This is so since the rules on tort are intended to regulate human conduct such that the person who willfully and negligently acts contrary to the social norm must be held for the injury caused. Example of which is, while hunting in State X near the boundary of State Y, Jim accidentally shot Ross, who was standing on a street in State Y. Here, the locus delicti is State X, because that was where the negligent act occurred. The number 2 theory is the common law theory, whereby the locus delicti is the place where the wrongful act became effective. The reason is that without an injury, there is nothing to protect and there is no necessity for judicial relief. In the above example, the locus delicti is State Y because it is where the place the wrongful act became effective. The third theory is the theory of Dr. Abel, where locus delicti is the place which has the most substantial connection with the wrongful act. Example of which is the situs of a radio station where a libelous broadcast is made is the locus delicti, even if the broadcast is heard in many places. Now, because of the difficulty in determining where the locus delicti is, some modern theories have been developed in determining liability for torts. The first rule is the rule of the state of the most significant relationship. This rule, as stated in the second restatement of 1969, is that the rights and obligations of the parties in a case of tort is determined by the local law of the state, which with respect to the particular issue has the most significant relationship to the occurrence and the parties. An example of this is the case of Babcock v. Jackson, 1963. Babcock and Mr. and Mrs. Jackson left New York, their residence, in the Jackson car driven by Mr. Jackson for a week's trip to Canada. While traveling in Ontario, Canada, Mr. Jackson lost control of the car and Babcock was badly hurt. Upon their return to New York, Babcock sued Jackson for damages under the New York law. Ontario's law does not allow any recovery. Can Babcock recover damages from Mr. Jackson under the New York law? The court held that yes, because all the dominant contacts and factors connected with the accident were in New York, namely, the parties resided in that place. Their guest-host relationship started in New York and was to end in New York. The car where the parties rode was garaged, licensed and insured was also in New York. So, the state of New York has the most significant relationship to the case. Another example is a case of Saudi Arabian Airlines versus CA 247 SCRA 469. The facts of the case are Saudi Arabian Airlines or Saudia hired Milagros Morada as a flight attendant for its airlines based in Jeddah, Saudi Arabia. While on a layover in Jakarta, Morada went to a disco with fellow crew members Thamer and Ala, both Saudi nationals. Because it was almost morning when they returned to their hotels, they agreed to have breakfast together at the room of Thamer, in which Ala left on some pretext. Thamer attempted to rape Morada, but she was rescued by hotel personnel when they heard her cries for help. Indonesian police came and arrested Thamer and Ala, the latter as an accomplice. Morada refused to cooperate when Saudia's legal officer and its base manager tried to negotiate the immediate release of the detained crew members with Jakarta police. Through the intercession of Saudi Arabian government, Thamer and Ala were deported and eventually again put in service by Saudia, but Morada was transferred to Manila. 1 year and a half later, Morada was again ordered to see Saudia's chief legal officer. Instead, she was brought to a Saudi court where she was asked to sign a blank document which turned out to be a notice to her to appear in court. Morada returned to Manila. The next time she was escorted by Saudia's legal officer to court, the judge rendered the decision against sentencing her to 5 months imprisonment and to 286 lashes. Apparently, she was tried by the court which found her guilty of number 1, adultery, number 2, going to a disco, dancing and listening to the music in violation of Islamic laws, and number 3, socializing with the male crew, which is also in contravention of Islamic tradition. After denial by Saudia, Morada sought help from Philippine embassy during the appeal. Prince of Makkah dismissed the case against her, and Saudia fired her without notice. Morada filed a complaint for damages against Saudia with the RTC of Quezon City. Saudia filed an omnibus motion to dismiss, which raised the ground that the court has no jurisdiction, among others, which is also denied. The issue here is that whether RTC of Quezon City has jurisdiction to hear and try the case. It was held by the court that yes, the RTC of Quezon City has jurisdiction and Philippine law should govern. Its jurisdiction has basis on Section 1 of RA 7691 and the Rules of Court and Venue. Pragmatic considerations, including the convenience of parties, also weigh heavily in favor of the RTC-QC assuming jurisdiction. Paramount is the private interest of the litigant. Weighing the relative claims of the parties, the Court ACO found it best to hear the case in the Philippines. Had it refused to take cognizance of the case, it would be forcing Morada to seek remedial action elsewhere, in the Kingdom of Saudi Arabia, where she no longer maintains substantial connections. That would have caused a fundamental unfairness to her. Moreover, by filing a complaint, Morada has voluntarily submitted to the jurisdiction of the court, and by filing several motions and praying for reliefs, such dismissal, Saudia has effectively submitted to the trial court's jurisdiction. The next theory is the interest analysis approach, wherein this approach considers the relevant concerns that 2 or more states may have in the case and their respective interests in applying their laws to it. Here, the state which has the most relevant and weighty interest in the case should be considered the locus delicti. The last theory is the Quiver's principle of preference. Under this theory, a higher standard of conduct and financial protection given to the injured party by one state is applied by the state where the injury happened, if the latter state adopts a lower standard of conduct and financial protection to the injured. Example of this is the case of Smith v. Driscoll Hotel 1947, where as a result of an illegal sale of liquor to X in the state of Minnesota, he, a passenger in the car driven by X in an intoxicated state, was hurt in an accident that occurred in the state of Wisconsin, sued for tort by T in Minnesota, X moved to dismiss the case on the ground that the accident happened in Wisconsin, the law of which required that wrongful act and the injury should happen in the same state before the recovery can be had. The ruling in this case is that to apply Minnesota law to the case would be more in conformity with the principles of equity and justice, since X's wrongful conduct was completed within Minnesota where X became intoxicated before leaving said state and before going to Wisconsin with T. Besides, the parties were both residents of Minnesota, whose law demanded a higher standard of conduct than that of Wisconsin, where the accident happened.